ఇంక్లూడ్ చేయొచ్చు. ద రీజన్ వై ఐఎమ్ నాట్ ఇంక్లూడింగ్ దోస్ ట్రివియల్ ఇష్యూస్, యూ విల్ నాట్ గో అండ్ రివైజ్. ఓకే, సో క్లాస్ గుర్తుపెట్టుకుంటారు. సో మళ్ళీ మన క్లాస్లో చెప్పిన మళ్ళీ రివైజ్ చేస్తున్నారా లేదా? ఓకే. సో అవును, అదేంటి పేపర్స్ రాసారా? ప్రీవియస్ ఇయర్స్ పేపర్ రాయండి. ఓకే, సో ఎక్కడ వరకు అయింది? గ్రామ్ న్యాయాలయస్ వరకు అయిపోయింది. ఓకే, so we have also done this question, right? So what was I discussing about Gram Nyayalais is, see, Supreme Court has given a judgment. It's not, although it was not binding, it was like it advised that you have to promote Gram Nyayalais, because until unless you don't promote this, what you say, judiciary at lower levels, what happened is the judiciary is being burdened. And in today's class also you will see about what you say, ad hoc judges. So ad hoc judges was also recently Supreme Court has given a judgment. The reason is, you see, when we are talking about what do you say, when we are talking about judiciary, first thing which comes with judiciary is delayed justice. So judiciary is also trying to address on this concept of delayed justice. So see, as we know that delayed justice is injustice. Okay, so if at all you are punishing a criminal after 10 years, okay, how do you consider this is nothing, this as upholding justice system? So that is the reason why delayed justice is being focused. And for that matter, you see, when we discussed about in the initial 23rd Law Commission, what did we say? Apart from DPSP, they are also talking about judicial reforms. So administration, so judiciary process was being emphasized. So whenever we are talking about judiciary, whatever committees has been appointed, so everything is trying to address this issue, trying to reduce this delayed justice. Okay, so this is also one such issue, and that is the reason why we see when we Nyaya Adhikaris are being appointed, not only that, conciliation means a kind of compromise is being settled. Okay, see, important takeaways from this is, as I said, no, so as we have discussed, this doesn't work directly under, like, okay, so we see principles of natural justice is being emphasized. Okay, we follow these principles of natural justice. National Human Rights Commission. So National Human Rights Commission, as you know, it is a statutory body. Okay, so when we are talking about prelims, you have to understand constitutional bodies, non-constitutional bodies are very much important. Okay, so do, as I said, no, try to emphasize, first finish this polity dimension. Polity topics are easy to score marks. Okay, so National Human Rights is a statutory body. It was established under that. Okay, so 1993 National Human Rights Act was being passed by Parliament in 1993. Okay, later we made some changes. So what we have to see in National Human Rights Commission is who appoints them. Okay, so President of India appoints them on the recommendation of selection committee. Who constitutes this selection committee? So head of the selection committee is Prime Minister. Okay, now the members include Union Home Minister, Speaker of Lok Sabha, and Deputy Chairman of Rajya Sabha. See, this is very much important. Here we are not talking about Chairman of Rajya Sabha. Why do you think that? Because Chairman of Rajya Sabha is Vice President. Okay, so Union Home Minister, Speaker of Lok Sabha, Deputy Chairman of Rajya Sabha, Leader of Opposition of Lok Sabha and Rajya Sabha. So you have 6 members. So 6 members selection committee would be there, and this selection committee is being chaired by Prime Minister, and based on the recommendation, President would appoint these members and Chairman of National Human Rights Commission. Okay, so they can be removed only on the charges of, okay, this more than this. This is one important. Neither the chairpersons or the members are permitted to seek further employment with the central government. So what is the application process, how they are being appointed? So like selection process enti, what is the selection process, who appoints them, and whether it is a constitutional, non-constitutional, or statutory, or is it an executive resolution body. Okay, these are issues. And you can also see that, like, if at all they are eligible for reappointment. Okay, so these all are the areas. Okay, so they are eligible for reappointment, but once the problem is reappointment. Okay, but they are not. However, if once the tenure completes, okay, so the tenure is 70, the term serve for a 3 years or until they reach 70 years. Okay, Santosh. Okay, whichever is eligible. Okay, so but once if there is their tenure completes, neither the chairperson or the members are permitted to seek further employment with the state or central government. You understand my point? So these are all the factual information which you have to know. Okay, so like now we have this. See, there is a selection committee which will be appointing the members of National Human Rights Commission. Now, who can be? What is the eligibility for this? Who can be the members of National Human Rights Commission? Okay, so a chairperson who is to be a retired Chief Justice of India. So basically, why National Human Rights Commission is so important is retired Chief Justice of India is going to be the chairman of National Human Rights Commission. And for that matter, you see, National Human Rights Commission is been represented in Chairman of National Human Rights Commission is represented in many international organizations also. Okay, so a member who has been a judge of Supreme Court. So you can see, you can go through this number, this what you say factual information. There is nothing to explain. But recently, National Human Rights Commission is in the news. So that is the reason why you have to know what is the composition and all. Now you see. Whenever an organization is in the headlines, whenever an organization is making headlines, definitely you have to know what is their appointment process, what is their, who appoints them, what is the selection process, and what is the composition of this commission. So that is the reason why you can see, look at the composition and you can read it out. Okay, so who can be the chairman, who can be the member. So 2 members should be the candidate with the knowledge on human rights. Okay, and there are ex officio members also. So in National Human Rights Commission also we have ex officio members, means National Commission for Minorities, National Commission for Scheduled Caste, National Commission for Scheduled Tribes, and National Commission for Women. Why do you think that these 4 commissions are being what you say considered as ex officio members? Because when you look at them, these are the vulnerable communities in our society. Vulnerability makes them, they are more prone to atrocities. You understand my point? That is the reason why when we are talking about Scheduled Caste Prevention of Atrocities, SC Prevention of Atrocities Act. Okay, so means nothing but based on caste equation, caste discrimination is happening. Not only caste discrimination is happening, caste atrocities are happening. Okay, and for that matter, many international human rights commissions, majority of the focus is trying to focus on women's rights, because many women are vulnerable to human rights violation. Okay, so this is the story with respect to National Human Rights Commission. Okay, answer this question. Consider the following organizations or bodies in India: National Commission for Backward Class, National Human Rights Commission, National Law Commission, National Consumer Dispute Resolution. What was the question? Or constitutional bodies. Okay, sir, gurtupettukondi. Today I will try to give you 2-3 examples also. Whenever you don't know a question also, by looking at options also you can eliminate answer, whether it might be the options, like in the questions they are given 4-5 statements, no, by looking at the statements also you can eliminate answer. So whenever, if in case you think that only I will answer those questions which I know completely, then the chances of you clearing will be very less. I'm not saying you can't clear, but it is, you should not expect that you should know everything in that question. And definitely in prelims you will be facing so many topics, many people you might not have heard of or you might not able to recall. బట్ చెప్తున్నాను చూడండి, చాలా మంది, నేను ఇప్పుడు స్టూడెంట్స్కి చెప్తాను, ఇఫ్ ఇన్ కేస్ 17,000 లిస్ట్లో తీశారనుకోండి పేర్లు ప్రిలిమ్స్లో, 17,000 or 15,000, 10,000 ఇప్పుడు పెట్టిన ప్రిలిమ్స్ రాస్తారు, ఇప్పుడు పెట్టిన క్వాలిఫై అవుతారు. ఓకే, ఎప్పుడు పెట్టిన క్వాలిఫై అవుతారు. సో ఎవ్రీ ఇయర్ 10,000 who have the objective knowledge, మీన్స్ ఈ ఫ్యాక్చువల్ ఇన్ఫర్మేషన్ గుర్తుండడం కానీ ప్రిలిమ్స్ క్లియర్ చేసే టాక్టిక్స్ ఉంటాయి. సో వాళ్ళు నేర్చుకొని ఉంటారు. లిస్ట్ లో కొత్తగా యాడ్ అయ్యారు అంటే 6 to 7,000, అంటే కొత్తగా అంటే లిస్ట్ విల్ బి అప్డేటెడ్ ఎవ్రీ ఇయర్, బట్ ద పాయింట్ ఇస్ వాట్ ఈస్ ద మైండ్ సెట్ ఆఫ్ స్టూడెంట్స్. సో 10,000 స్టూడెంట్స్ వాట్ ఎవర్, నేను ఇప్పుడు కూడా చెప్తున్నాను చూడండి, ఆ 10,000 స్టూడెంట్స్ ఆల్రెడీ డిసైడెడ్ ఈ 7 to 8,000 ఉంటాయి చూడండి, అవే ఫ్లక్చువేట్ అవుతారు. సరే ఎప్పుడు ఫ్లక్చువేట్ అవుతారు అంటే ఆన్ ద డే ఆఫ్ ఎగ్జామ్. On the day of exam, you are not using your common sense knowledge. You are not keeping your nerves under control, losing your control, losing your calmness. Then you will be out of the list. And చెప్తున్నాను చూడండి, ప్రిలిమ్స్ క్లియరింగ్ చాలా మంది, సి ఇంటర్వ్యూలో లిస్ట్ ఫైనల్ లిస్ట్ లో పేరు రావడం, మెయిన్స్ లో లిస్ట్ రావడం, ఐ కెన్ సే దట్ దోస్ పీపుల్ ఆర్ సో మచ్ స్కిల్డ్ టు క్లియర్ దిస్ ఎగ్జామినేషన్. బట్ ప్రిలిమ్స్ లో ఏమవుతుంది అంటే చాలా వరకు ఎగ్జామ్ హాల్ వరకు దే ఆర్ క్యాపబుల్ క్యాండిడేట్స్ క్లియర్ దిస్ ఎగ్జామినేషన్. మాక్ టెస్ట్ లో మంచి మార్క్స్ వస్తాయి, బట్ సడన్ గా ఎగ్జామ్ లో ఒక 2-3 క్వశ్చన్స్ సరిగ్గా చేయకపోయేసరికి, అవుట్ ఆఫ్ 100 క్వశ్చన్స్ 2 or 3 క్వశ్చన్స్ సరిగ్గా చేయకపోయేసరికి యూ విల్ లూజ్ యువర్ కామ్నెస్. ఓకే, ఐ హ్యావ్ సీన్ మై స్టూడెంట్స్. సో లాస్ట్ టైమ్ దెర్ వాజ్ one student who prepared, and first 3-4 questions she was not able to do, and there was a question on organization which is relating to toilets. Okay, so previous year question, when she realized that question, what type of question paper is this? Okay, see, such a type of questions also would be asked. It doesn't mean that rest of the 99 questions would also be on the same lines, but if at all you are not, that's what I always tell to my students, I always ask my students is, take this 100 questions like 100 questions. Make sure that every question, how much attention you have to give, that much only attention you have to pay. Means nothing but, మీకు నేనేం చెప్దాం అనుకుంటున్నా అంటే, మీకు తెలిసిన క్వశ్చన్ కూడా తప్పు చేశారు అనుకోండి, ఇట్స్ ఓకే. బట్ నేను తెలిసిన క్వశ్చనే తప్పు చేశాను అనుకొని ఆ క్వశ్చన్ గురించి బాధపడితే రెస్ట్ ఆఫ్ ద 99 క్వశ్చన్స్ విల్ బి ఇంపాక్టెడ్. ఇప్పుడు మీరు ఫస్ట్ చూడండి, కొంతమంది ఏమవుతుంది అంటే మైండ్ సెట్ ఎలా ఉంటుంది చూడండి, కొంతమంది 88th క్వశ్చన్ లో కూడా చాలా మంది ఉంటారు, ఆ ప్రెషర్ లో తెలిసిన క్వశ్చన్ కూడా తప్పు పెడతారు, లేకపోతే అక్కడ టిక్ కరెక్ట్ పెట్టుకుని బబ్లింగ్ తప్పు చేస్తారు. సో అదే ఇష్యూ ఫస్ట్ క్వశ్చన్ అయింది అనుకోండి, డోంట్ యూ థింక్ రెస్ట్ ఆఫ్ ద 99 క్వశ్చన్స్ విల్ బి ఇంపాక్టెడ్? ద ఛాన్స్ ఆఫ్ దట్ క్యాండిడేట్ క్లియరింగ్ విల్ బి లెస్. బట్ ఇఫ్ ఎట్ ఆల్ అదే ఇష్యూ 98th 95th క్వశ్చన్ లో జరిగింది అనుకోండి, ఆ క్వశ్చన్ రిమైనింగ్ 5 క్వశ్చన్స్ మీద ఇంపాక్ట్ పడుతుంది కదా. సో దట్స్ వాట్ ఐఎమ్ ట్రైంగ్ టు సే. Take this as an examination of 100 questions where you have to give equal importance to 100 questions. I'm not talking about time. I'm talking about thought process, how you are going to take that question. So please be careful. Okay. So ఇవన్నీ చాలా మంది ఎగ్జామ్ కన్నా ముందు చెప్తారు. ఓకే, టుమారో దెర్ ఇస్ అన్ ఎగ్జామ్, ప్లీజ్ బీ కేర్ఫుల్. మనకు ఆ ఎగ్జామ్ అదే ఉంటుంది చూడండి. చాలా మంది ఇప్పుడు ఇన్స్టిట్యూట్ వాళ్ళందరూ వీడియోలు పెడతారు అనమాట, రేపు ఈ జాగ్రత్తలు తీసుకోండి, ఈ జాగ్రత్తలు తీసుకోండి. మనం పెన్ను పెన్సిల్ తీసుకున్న జాగ్రత్తల్లోనే ఇవన్నీ మర్చిపోతాం. సో అందువల్ల నేనేమంటానంటే ఇలాంటివన్నీ ఇంటర్నలైజ్ చేసుకోవాలి. యూ హ్యావ్ టు ఇంటర్నలైజ్ దిస్. దట్ ఈస్ వాట్ ఐఎమ్ ట్రైంగ్ టు సే. నో, యూ వాంట్ టు డూ ఎక్స్పెరిమెంట్, యూ డూ నాట్ ఇన్ ఎగ్జామ్. యూ హ్యావ్ టు డూ దట్ ఎక్స్పెరిమెంటింగ్ ఫ్రమ్ నౌ. అండ్ వెన్ యూ డూ దట్ యూ విల్ ఇంటర్నలైజ్ ఇట్. అందువల్ల చూడండి, ఒక్కసారి ప్రిలిమ్స్ నా లాజిక్ ఏంటి అంటే ఫస్ట్ టైం ప్రిలిమ్స్ క్లియర్ చేసిన వాడు సెకండ్ టైం ప్రిలిమ్స్ క్లియర్ చేస్తాడు, థర్డ్ టైం కూడా క్లియర్ చేస్తారు. చూడండి చాలా మంది ఫస్ట్ టైం ప్రిలిమ్స్ క్లియర్ చేయని వాళ్ళు సెకండ్ టైం క్లియర్ చేయకపోవడానికి ఛాన్సెస్ కొంతమంది ఉన్నారు. అలా అవుతుంది అవ్వదు. బట్ పాయింట్ ఏంటి అంటే వన్స్ యూ గెట్ ద నాగ్ టు క్లియర్ దిస్ ప్రిలిమ్స్ ఎగ్జామినేషన్, యూ గెట్ దట్ స్కిల్ సెట్, దెన్ ఇట్ విల్ బీ లైక్ ఎ కేక్ వాక్ ఫర్ యూ, ఫర్ ఎనీ వన్ టు క్లియర్ ప్రిలిమ్స్. టెన్షన్ ఉంటుంది బట్ ఎగ్జామ్ వాళ్ళకి పోయేటప్పుడు కూడా వాళ్ళకి కాన్ఫిడెన్స్ ఉంటుంది, ఏంటి నేను ఆల్రెడీ ప్రిలిమ్స్ క్లియర్ అయ్యాను నాకు తెలుసు. సో పాయింట్ ఏంటి అంటే ఎప్పుడు క్లియర్, ఇక్కడ మనం అర్థం చేసుకోవాల్సింది ఏంటంటే ఎప్పుడు ప్రిలిమ్స్ క్లియర్ చేసే వాళ్ళు కూడా ఎగ్జామ్ హాల్లో అన్ని క్వశ్చన్స్ తెలియదు, ఎగ్జామ్ హాల్లో మిస్టేక్స్ చేస్తారు, మీలానే మిస్టేక్ చేస్తారు. కానీ డిఫరెన్స్ ఏంటి అంటే దే విల్ నాట్ టేక్ వన్ క్వశ్చన్ టు దేర్ హార్ట్ అండ్ impact other, show that impact on other questions. So these are the subtle things which you have to be very much careful. Okay, so ఇప్పుడు చూడండి, when you know that National Human Rights Commission is a statutory body, by eliminating that also, so you can see which of the above are which of the following are constitutional bodies. So you can know that, see, recently National Commission for Backward Classes has been provided constitutional status. Okay, so by that also you can see, that's what I am saying, అన్ని క్వశ్చన్స్ తెలియాలని లేకపోయినా, అన్ని ఆప్షన్స్ తెలియలేకపోయినా కామ్ గా ఉండి చూడండి, ఒకసారి చదివితే అర్థం కాకపోయినా క్వశ్చన్ చదవండి మళ్ళీ ఇంకోసారి. అండ్ ఇంకోటి చాలా మందికి చెప్తున్నాను చూడండి, పెద్ద పెద్ద క్వశ్చన్స్ ఇస్తే నేను ఈ పెద్ద క్వశ్చన్ తర్వాత చదువుతాను అనుకుంటారు, ఈ పెద్ద క్వశ్చన్ ఏదో డిఫికల్ట్ ఉంటుందని. అండ్ క్వశ్చన్స్ విత్ బిగ్ స్టేట్మెంట్స్ విల్ ఆల్సో బి వెరీ ఈజీ. బట్ ఫస్ట్ టైం చదివినప్పుడు అర్థం కావచ్చు స్ట్రెస్ లో, ఓకే లీవ్ దట్ క్వశ్చన్, బట్ అగైన్ కమ్ బ్యాక్ వెన్ యూఆర్ కూల్ మైండెడ్ అండ్ రీడ్ దట్. ఒకసారి క్వశ్చన్ చదివితేనే మీకు ఆన్సర్ వచ్చేస్తుంది. అలాంటి క్వశ్చన్స్ కూడా ఉంటాయి. అదే చెప్తున్నాను చూడండి, ఎవ్రీ క్వశ్చన్ హ్యాస్ ఈక్వల్ మార్క్స్, ఎవ్రీ క్వశ్చన్ యూ హ్యావ్ టు పే దట్ ఈక్వల్ అటెన్షన్. ఓకే, చలో నౌ లోకాయుక్తాస్ అండ్ లోక్పాల్. ఓకే, సి యు నో ఇన్ ఇండియా against corruption in government institutions was happening. So then we see Lokpal movement as done. So from then onwards we see Lokpal and Lokyukta Act was been passed in 2013. Okay, so Lokayukta serves as an anti-corruption authority at state level and Lokpal serves as an anti-corruption authority at central level. The structure of Lokayukta is not uniform in all states. So because according to the necessary, because one size doesn't fit, so necessary changes has been made by states. But you have to understand that Lokayuktas are appointed by the governor. Who appoints? Governor of the state after consulting the Chief Justice of High Court. Okay, Lokayuktas are appointed by governor of the state after consulting the Chief Justice and the leader of opposition. Okay, so this is about appointment and composition. You have to understand that chairman and a maximum of 8 members with at least half being judicial members. So half members should be from judicial background and rest of the 50 members should be from scheduled caste, scheduled tribes, other backward classes, minorities and women. Okay, so this is the story with respect to functions and powers of Lokpal. You can see, one thing which I wanted to discuss is, when we are talking about powers, you have to understand that Lokayuktas also have the power to question bureaucrats. Okay, powers, yeah, Lokayukta is equipped with the authority to recommend the suspension or transfer of civil servants connected with the corruption allegation. Recommend చేస్తారు వాళ్ళు, recommendation. But see, majorly when we are talking about the Lokpal Lokayukta designation, structuring is in such a way it will recommend. So see, that is a reason why you see when we are talking about Lokpal and Lokayukta, still there are so many peer groups working continuously to make Lokpal and Lokayukta more effective. Why that discussions is going on? Because we also want that restructuring of it. We want to make it more effective. Okay, RTI, Right to Information Act. See, why? See, just now we discussed about Lokpal and Lokayukta. What is happening is, we see from 2005 onwards, we see whether it might be judiciary or whether it might be legislative. Okay, this is a fact. This is being observed that because of judicial intervention, because of not only judicial intervention, we cannot only say judicial intervention, because of judicial interpretation also you can say, and because of legal, means nothing but amendments to this RTI Act. What happened is, in this process we see RTI is being weakening. So that is the reason why many pressure groups, okay, so many NGOs are coming together and trying to say that we want to revive the glory of RTI. Okay, so that is the reason why RTI is in the news. Now you understood why RTI is in the news. RTI is one of the powerful tool in the hands of in a democratic setup, in the hands of a citizen. But what is happening, why it is very much a powerful tool in the hands of a citizen is, it can question, it can emphasize, it is promoting transparency and accountability. Okay, it promotes transparency, it promotes accountability on the exchequer, it also promotes accountability on the executive or legislative. Okay, that is the reason why you see this is one of the powerful tool in India. But what happened is, deliberately we see weakening of RTI in these days. Okay, not only legislative, okay, not only through law, not only through acts or through amendments or through changes which has been done. See, it is not only, see, when we are talking about weakening, is not merely about, you have to understand, there is two-pronged impact, two-pronged ways also when we are talking about legislative. One is by making some amendments. Second thing is, how can you weaken RTI? Modify చేయడం అంటే అమెండ్మెంట్స్ కానీ చేంజెస్ కానీ, ఇంకెలా వీకెన్ చేస్తావు? అపాయింట్మెంట్స్ ప్రాపర్ గా చేయకపోవడం, delayed in appointment. So overall, can I say, by not implementing RTI effectively? RTI has to be implemented by executive or legislative. Okay, legislative means nothing but whether it might be chief minister or whether it might be secretariat or collector. You understand my point? So permanent executive or legislature. So MP, MLA, all these people. Now the argument here is, now RTI would question these people, and these people have to make it more effective. So that is the reason why, as this is questioning their accountability, so they are devising new means to make RTI ineffective. And a simple point in that, if at all I file an RTI, I should get the information very quickly, but within 1 month. For suppose there is a time limit of 1 month, okay, or there is a time limit of 48 hours. So within that also you are not able to get information. Now you understand my point, what I meant by weakening. Weakening means nothing but they are this type of divisive. And second thing is judiciary also. We will look into the dimension of judiciary also. First you have understood the legislative dimension, how this weakening is happening. So first thing is, weakening is, we see like RTI amendments or changes in this, and main another dimension is not implementing it effectively, not making it a full member body also. So or appointments with respect to RTI. So these all are disturbing and weakening this RTI. So that is the reason why this is in the news. Now you have to understand, okay, now you have to understand, Right to Information Act is a landmark legislation in India that empowers citizens to access of information held by public authorities, thereby promoting, as I said now, transparency, accountability and participatory governance. So it is an initiative taken by Department of Personal Training, Ministry of Personnel and Grievances. Okay. I said no. How it is making ineffective is usually within 30 days or 45 hours in case of involving life or liberty. But within that they are not responding. Okay. When we are going for grievance redressal also, there is no proper grievance redressal. Okay. Now, what are the judicial interpretations restricting RTI or weakening RTI. See, what happened was there are two cases which you have to understand. Okay, there are two cases which you have to understand. So, one such case is Central Board of Secondary Education versus Aditya Bandyopadhyay. See, in this what happened was, okay, so what is the Supreme Court is the judgment challenged the strict implementation of Section 8 which outlines exemptions to the Right to Information Act. You have to understand that, sir, major debate with respect to RTI. So, major debate with respect to RTI, everyone you should understand is this is about Section 8 of RTI. Okay, Section 8 of RTI. Sir, what is this Section 8 of RTI is? This Section 8 of RTI is talking about some exemptions. Okay. Now, TGPSC has conducted this examination. Now, when students are saying that we have some doubts with respect to evaluation or we have some doubts with process of examination, when they are filing RTI, then they are saying that this is a sensitive information. We can, as it is our constitutional body, we cannot disclose that information. You understand my point? So yes, the section itself is having certain exemptions, but the exemptions are being broadening. You understand my point? That is how you can see this weakening of RTI. Now, I hope you got what I am trying to say. Is it clear? So, what happened was the court assertion that indiscriminate of, listen, this statement you look carefully, indiscriminate use of RTI could hinder administrative efficiency. So, when you are using RTI indiscriminately, means nothing but there is a collector. Okay. So, every day against that collector 25 to 30 RTIs is been filed. Now, don't you think RTI, if at all an RTI has been filed, immediately that collector have to give a response. Means collector won't give a response. There is an information authority who has been appointed. He will be giving. But don't you think he need to ask from collector why this funds has been allotted, on what basis this has been allotted. Now, basically collector would be very busy. Okay, that is the reason why you see whenever you talk about government authority who is in power, they will be saying that most of the time they will be spending on paperwork only. Paperwork means nothing but these type of issues. Not only RTI, there will be n number of paper files, n number of signatures which you are supposed to do. Okay, so now this was the interpretation of Supreme Court. That is nothing but the court accepted. The court said that indiscriminately you should not use RTI, because if you use indiscriminately, what happens is administrative inefficiency would be impacted. So this perspective, what happened was this perspective justified the denial of information. So in some cases, as this RTI is used indiscriminately, okay, you are using it many a time. So the concept of denial of information, see, you have filed 10 number of RTIs. Okay, there is an NGO organization. Now that NGO organization is filing a RTI in all the department. See, as a right, that NGO can do it because NGO want to promote accountancy and transparency. But you see, when you are blacklisting that NGO and you are saying that whatever NGO that is filing RTI, we will not give information. So this judgment was interpreted as denial of information. Means right to information is access to information. But Supreme Court's interpretation to a certain extent is nothing but this justified the denial of information. You understand my point? On broad grounds and cast suspicions on RTI applications, leading to an environment where transparency was seen as an obstruction rather than a fundamental right. Now you see, transparency should be like right to information. Information should promote transparency. But now the same information was seen as an obstruction. You understand my point? How this debate has been started. Why RTI was in the news. Next, there was another case also, which was Girish Ramachandran Deshpande versus Central Information Commission. Central Information Commission is the apex body which implements RTI. So Central Information Commission you have and State Information Commission you have. Now from examination point of view, now don't you think CIC appointment is very much important? CIC, who appoints CIC, what is the power, what is the tenure, whether he is eligible for reappointment, all these things are very much important. So write down and look into that. Okay, when you are studying polity, CIC ni proper గా రివైజ్ చేసుకోండి. సో లాస్ట్ మూమెంట్ రివిజన్ లో CIC పెట్టుకోండి. So the court ruled that information about public servants disciplinary records, this judgment is also very much important. The court ruled that information about public servants disciplinary records and financial dealings were personal. Means nothing but when it is a personal issue, it doesn't come under RTI. You have certain exemptions, no? You cannot disclose personal information. Now that is the reason why you see why many public employees don't disclose their personal information is because of that. Someone might file RTI, but Supreme Court only interfered. So in this case saying that whatever means nothing but if at all there is an officer, so his behavior is not good, his behavior particularly with women is not good, so someone filed an RTI. So he might have misbehaved with someone and he have disciplinary record. Okay, indisciplined record he might be having, but when I file an RTI I cannot get it because it comes under comes under his personal record. Now don't you think by RTI which have to promote transparency, which have to promote transparency and make public officers accountable, now such a type of interpretation, don't you think that RTI is being weakening? So that is the reason why we see there was a movement which is happening, there was a mobilization amongst the masses. Intellectuals are being mobilizing, although it did not become a mass movement, but intellectual movement has been started wherein intellectuals are questioning the weakening of RTI. Now you understood my point. So the court set a precedent that allowed authorities to withhold crucial information. Now every crucial information they are saying that no, this is personal. You understand my point? When they are interpreted this as an exemptions, now they are saying that this is a crucial information we cannot disclose. Okay, so this is how we see weakening of RTI. So civil society members and lawyers and experts have demanded immediate rollback of amendments made to the RTI Act through section 43 and now why this is in the news is another reason. So that is one argument. So till now what we have said is we looked into legislative thing, how amendments is being made to RTI, how it will be impacted, and we also looked into from the dimension of judiciary. Now recently what type of legislative means has been made and which is weakening RTI is Digital Personal Data Protection Act 2024. Okay, this Digital Personal Data Protection Act is also imposing restrictions on RTI. Okay, so this is not 2024, this is 2023. Okay, Digital Personal Data Protection Act 2023 as a double-edged sword, arguing that while RTI Act restricted access to public information, the centralization of power through government controlled data protection could be vaporized. Means nothing but, see, under this Digital Personal Data Protection Act, what happens is, see, you are controlling the data of the people and you are controlling this data protection, and data is controlled in the hands of government. Now whenever and enlightened individual or whenever a responsible individual is questioning government, for suppose if at all I have a problem with chief minister or a problem with prime minister, so now don't you think I can question, because if at all they are involving in illegal activities, as a citizen I have the right. Okay, but now don't you think sometimes if my data is in the control of this government, if I am questioning, I am repeatedly questioning, now don't you think my personal data might be misused against me? Okay, so this is what is also happening. So there are so many folds where are hindering transparency. That is the reason why this RTI was so much in the news. Majorly enti ante mains perspective lo chala important, but you have to understand that from prelims perspective also there is a scope of asking. So mostly they might ask that these cases are related with which, okay, or how, what you say, like they might ask about chief information, CIC, okay. So what is the governing structure of RTI? These questions may be asked, but when we are talking about mains, it will be very much important, okay. So objectives of RTI Act we discussed now. Next, Supreme Court. So you see, Supreme Court, please read, I think this is 75 years, like, so 75 years of Supreme Court. So that is also the reason why Supreme Court related articles will be very much important. So like you have to understand what is the article which talks about Supreme Court. So 75, we are entering into 75 years of history of Supreme Court. So Supreme Court related question might be asked. So this is how you have to do that smart study, which institution, from where we can get questions. So 26, you can see this is all factual information. So you can read this information like appointment చూడండి, removal చూడండి, tenure చూడండి, okay, whether he can be appointed or not, how, if at all he want to, what you say, what is the, he remains in office until he reaches the age of 65. So what is the age, what is the tenure, what is the appointment process. So all these things you have to see. Especially you have to understand the difference between what is this original jurisdiction, writ jurisdiction, appellate jurisdiction, and advisory jurisdictions. Okay, this is, should I explain it? Okay, so now, so right, answer this question. See, that is purely polity related, no, but I am trying to emphasize that you have to go through this, and why from current affairs perspective also. So please go through that, and you have to look what is this appellate jurisdiction and the writ jurisdiction and the advisory jurisdiction, and this is very much in the news. Article 143, the advisory jurisdiction of, means under this advisory jurisdiction, president can seek an opinion from Supreme Court on any question of legal inquiry or fact of public information on which he thinks it is a matter of serious concern to obtain such an opinion. So whenever president thinks it is necessary to consider, to ask an opinion, he would do that based on Article 143. So writ jurisdiction you have to understand. So whether the writ jurisdiction of Supreme Court is broad or High Court is broad. So all these issues which you have studied, try to revise that. It will be very important from examination point of view. Next, answer this question. A writ of prohibition is an order issued by Supreme Court or High Courts to lower court prohibiting continuation of proceedings in a case and taking that into their hands. So that is writ of prohibition. Certiorari, quo warranto, prohibition, okay, mandamus, okay. So this, now next, 6A of citizenship. So this is so much in the news. Can someone explain me what is this 6A of Citizenship Amendment Act? తెలుసా అంటే సార్ ఏమన్నా illegal migrants to India or 6A. Why 6A is in the news? Okay, అది citizenship amendment. మీరు అదే అనట్లేదు. This 6A of citizenship is talking about Assam Accord. Okay, it is talking about Assam Accord. Okay, so let us discuss about this Assam Accord. So why this? Now first you have to understand. మీరు అన్నది ఇది సార్. So what is this? What is the principle of naturalization? అవి. So here 6A, why it is in the news is recently Supreme Court upheld the constitutionality of 6A. Okay, this 6A is in the context of Assam Accord. 6A of Assam Accord. So first you have to understand what is this Assam Accord, what is this 6A, and what is Article 6 and Article 7 of Indian Constitution. Article 6 and Article 7 of Indian Constitution is talking about citizenship, and how this Article 6A is related with that, we will be looking into it. So as I said, last class you might have heard about that Bangladesh shares major land boundary with India. So it is when the land boundary of with Bangladesh and India is somewhere around 4,000 kilometers. Now don't you think there will be many porous borders through which Bangladeshis can easily come? So as Bangladesh is sharing borders with many Indian states, Assam is one such state. Many people from Bangladesh are migrating to Assam. So that is the reason why migration of these people into Assam is increasing. Not only to Assam, all those northeastern states, but in migration to Assam was more. Okay. Now, what is the issue in Assam was, these Assam people who were locals, gradually their proportion of population is coming down, and they are thinking that their culture, Assamese culture, is at stake because many other migrants are coming. Okay, so that is the reason why you see Assami people has opposed to this 6A. Now first, before understanding this, why, that is the reason why they have filed a case. Before understanding this, what is this Assam Accord? As I said, there are many people who are migrating to Assam. So people of Assam protested, saying that our Assam culture is at stake, our Assam jobs is at stake. Assam, what you say, in Assam, students, original inhabitants of Assam, were losing job opportunities, education opportunities, and what you say, they are not able to uphold their culture. They feel that their culture is being, what you say, declining. Okay, their identity is at stake. So these are all the issues. So there was a mass student protest. So finally in 1985, Assam Accord was finalized between Rajiv Gandhi and Students Union from Assam. Now what this Assam Accord has been done, now you understood the historicity. Now what it has been done is, when was this Bangladesh Liberation War fought? 1971. So before Bangladesh, after Bangladesh Liberation War, many people migrated to India, particularly they came to Assam. So to the question, now you understand my point. This is their land, but many people are migrating to Assam, and that is the reason why you see now also in Assam, many, what you say, refugee camps are located all over Assam. Some districts are covered entirely with refugee camps or illegal migrants. Okay, so in Assam, citizenship is a big issue. Who are actual citizens of Assam? Or as actual citizens, as we don't have dual citizenship, who are actual citizens of India? Who are these indigenous people? So Assam Accord has been finalized to stop this migration. Okay. So in Assam Accord, what it has been done is, so there was two timelines which you have to understand. One is till 1966 and other is 1966 to 71 and after 71. Okay, I'll explain you roughly. Ee dates and important raktaina. Okay, see, 1966, 1971 and after 1971. So people who migrated, what is that Assam Accord which has been finalized is, people who have migrated to Assam before 1966, they have given citizenship. People who migrated to, means agreement is about who should be given citizenship, who should be recognized as a people. Now this is been finalized when what? 1985 Accord. You understand my point? By that time, almost they have lived in Assam for 20 years. Okay. Okay, now by taking your consideration also, people who have migrated. Okay, so in 19 before 1996, okay, how many whoever have came to Assam, they have given citizenship directly. After 1966 and before 1971, whoever migrated to Assam, they have given citizenship but with a condition. But whoever have migrated to Assam after 1971, they have been termed as illegal migrants. You understand my point? So this is the accord which is been finalized. So that is the reason why you see in all other states, when elections arises, there are so many issues with which elections are being fought, whether it might be caste equation, whether it might be religion equation, whether it might be what you say, who is the proper Telangana leader, who is the local, all these things. But in Assam, whenever elections are being fought, always it is been fought about citizenship. Because many people who came to India after 1971 also, by using forgery documents, they claimed themselves to be people who came before 1966. Okay, now you understood the story with respect to Assam Accord. What is the issue which is prevailing in Assam Accord? Now, what happened is, this 66A clause was talking about these things. Okay, so it is talking about these things. Now you understood my point? You understood the brief history with respect to this Assam. What is Assam Accord? What is this? Timelines are given together. Before 1966, whoever came, they have given citizenship. Means whoever came after 1966, before 1971 also, before the start of Bangladesh war, they also given citizenship, but with condition. Means nothing but condition means, for 10 years you will not have voting right. For 10 years you will not get these schemes. With conditions means. So this is what is decided. Now you see. Now you come to 60A of citizenship. 60A originates from the Assam Accord, a political settlement signed on August 15, 1985 between Rajiv Gandhi led Congress government and Assam students, Assam Gan Parishad students organization, following a 6-long hesitation against the influx of undocumented migrants from Bangladesh into Assam. Now what is the provisions of this Assam Accord? 6A. The provision has also conferred Indian citizenship upon migrants of Indian origin who entered Assam before 1st January 1966 and have been ordinarily resident in the state since then. Means nothing but ordinary resident means they have given citizenship. Meanwhile, those who arrived between January 1st and March 24th, okay, were granted full rights of Indian citizenship except for voting rights which were held for a decade. Means in 1971 they might get citizenship, but they will get voting rights only after 1981. Now you understood what is the provisions of this 6A. So recently these provisions were being questioned. These provisions has been questioned, saying that because see, actually in India, now how this provisions has been questioned. In India, what happens is, in 1950 when we are formulating constitution, you have Article 6 and Article 7. So Article 6 and Article 7 is talking about citizenship. Now this citizenship provisions is saying that whoever migrated to India after some timeline, especially from Pakistan or all these areas, we will not give them citizens and we will treat them as an enemy aliens. You understand my point? So they questioned, saying that these 6A provisions, these provisions are unconstitutional because these provisions are against Article 6 and Article 7 of Indian Constitution. So this is the claim of people who questioned this. Why they are questioning this? Because many people are getting citizenship through this process and they are illegal migrant. So this was questioned in Supreme Court. Supreme Court said that these provisions is not against Article 6 and Article 7 because these provisions did not formulate during formation of independence. Constitution was formulated during that point of time. This provision was included as a complementing provision to citizenship. So, and they upheld this 6A of citizenship. Now you have understood. Now you understood why this 6A was in the news. What is this 6A? What is the provision of 6A? So Supreme Court, after long legal battle, has upheld the 6A. That is the reason why this is very much important. Now again I am saying, what did Supreme Court say is, Supreme Court said that upheld the constitutionality of this and saying that this is not against 6 and 7 of articles or articles of Indian Constitution, because those articles were formulated during that point of time, taking conditions during that period of time into consideration. And you further matter, this 6A was also an agreement which is not signed by state. It is an agreement which is signed by central government. And central government has formulated a policy, included a provision for citizenship. So that is the reason why it is not unconstitutional. Now you understood what is this 6A? Okay. So now you can look at this citizenship. Okay. So what are the factual information with respect to the citizenship? Indian citizenship can be lost. So based on renunciation. So నీకు ఇష్టం లేదు ఇండియన్ సిటిజన్షిప్ గా ఉండడం. సో వాలంటరీ యాక్ట్ వేర్ అన్ ఇండివిజువల్ గివ్స్ అప్ దేర్ citizenship. Next, termination occurs when an Indian citizen voluntarily acquires the citizenship of other country. Okay. Deprivation, it is compulsory termination by the central government under specific consideration. Okay. So ఎప్పుడైతే deliberately you are going against the nation's interest and all, so then they will be depriving your citizenship. Don't get confused between termination and deprivation. Okay. So then citizenship of India can be acquired by what is that? Birth, descent, registration, naturalization, incorporation of territory. Okay. Next, renunciation, acquisition of another country, deprivation. So these are all the criteria where Indian citizenship can be acquired. Now I try to explain what is termination, what is deprivation. So look into this factual list. The constitution does not define the term citizen. ఇలాంటి క్వశ్చన్స్ అడుగుతున్నారు. Does our Indian constitution define the term citizen? Constitution of India provides for single citizenship for the whole of country who was born in India, domiciled in the territory of India, and who was born in India, or either whose parents was born in India, who has been ordinary resident of India for not less than 5 years, became citizen of India. Next, Citizenship Act was amended. Okay. So Citizenship Act was so recently also amended when we are trying to provide citizenship to religious minorities in our bordering countries. Okay. So 6A is utmost important. Okay. So RTI is important, 6A is important. So you should understand how much level of understanding is needed when it comes to RTI and all. Okay. So prelims revision galani, I am not only focusing on factual information also. Conceptual clarity is also very much important, because if at all they ask a question in RTI and 6A, you need to have conceptual clarity. It's just not that they will ask about 6A is related with what. Okay. Interlinking is also very much important. Smart cities. Okay. Smart cities, see, actually this was in the news. Recently we are discussing about smart city, enabling smart city. There were articles which was there on smart cities. So you have to understand smart cities comes under which ministry and what is the funding mechanism. It is centrally sponsored scheme. What is the difference between central sector scheme and centrally sponsored scheme? Centrally రేవంత్ రెడ్డి కొంచెం పెట్టుకుంటాడు, నరేంద్ర మోడీ కొంచెం ఇస్తారు, అంతేగా. Okay, smart schemes, smart city features, promoting mixed land use, okay, housing and inclusiveness. Sir, this is very factual information. As it is in the news, I have given that. Now, governor selection process is also so much in the news, because you see recently Supreme Court, see whether it might be in Tamil Nadu, whether it might be in Kerala, we see about the role of governor, about the not only role of governor, appointment of governor is debated, functions of governor is debated, discretionary powers of governor is being debated. Okay. So already I asked your sir, so in polity he said that I have discussed all the factual information with respect to governor. So ఈ governor లో ఇంకేమైనా డౌట్స్ ఉంటే అడగండి మీరు. Okay, otherwise you just go through these provisions. I think that not much to explain, but what is the topic which want to explain from the from the lens of governor is, recently Supreme Court has given a timeline for the governor regarding how he should act on bills. And recently Supreme Court said that governor, you don't enjoy pocket veto or absolute veto. So this is also these two issues which you are supposed to know. And that is the reason why you see Tamil Nadu government, okay, as governor is upholding his assent. They have issued a gazette notification saying that as Supreme Court has given some timelines to governor and governor is not abandoned, that is the reason why we are considering them as passed. And they have issued gazette notification. First time in the country. Yeah, that is the reason why this issue is there. So go through this question. Okay, Ladakh and 6th schedule. This is very much important. Ladakh and 6th schedule. Okay, so the argument is, earlier Jammu and Kashmir was a state. Now after abrogation of Article 370, we made Union Territory. Jammu and Kashmir and Ladakh as separate Union Territories. Now Jammu and Kashmir is a Union Territory with legislature and Ladakh don't have a legislature. Now this is clear, this factual information, everything everyone knows. Should I move forward? Now Ladakh is saying that we want to be recognized as a territory under 6th schedule of Indian Constitution. Now what is this 6th schedule of Indian Constitution? There are two schedules, okay, 5th schedule and 6th schedule, scheduled areas we call. So 5th schedule and 6th schedule means nothing but these are the areas to protect the interest of backward communities. We have designated some special, what you say, special policy measures in such a way such that they can have some kind of welfare measures, they can have some kind of autonomy. Okay, so this is there. Now what is the defining features with respect to the 5th schedule and 6th schedule, and why Ladakh demand cannot be met constitutionally? See, in India already you have, before going further you should know, already Ladakh was having this kind of regional autonomy during before abrogating Article 370. But now people of Ladakh, why they are demanding this autonomy under 6th schedule is because they were traditionally they were having that autonomy, but by abrogation of this Article 370 and making Ladakh as a union territory. Union territory means nothing but direct central governance. So that is the reason why they are feeling that they have deprived of political representation. Now the major argument of people of Ladakh is you have deprived them of political representation. Before, when Ladakh was the part of Jammu and Kashmir state, they have MLAs, they have MPs. Now, as you see, there is no legislature, so they have been deprived of this political representation. Not, see, definitely, I'm not talking about territorial thing. I'm talking about the regional, local bodies. Okay, so this political representation, okay, this political representation is not been there under this union territory. That is the reason why people of Ladakh are demanding for autonomy. And in autonomy, in what sense? Recognize Ladakh as a 6th schedule area. Now why central government, why giving 6th schedule status to Ladakh is not what you say, it doesn't go well with constitution is we implemented 6th schedule specially to the northeastern states. Okay, now the demand of Ladakh doesn't come, Ladakh geographically doesn't come under northeastern states. So that is the reason why also we are thinking. And now see, when we are talking about you have to understand the debate here. This is like two sides of a coin. There are both merits and demerits. Okay, so from when you look from the local peoples, they are thinking that local, I'm not talking about MLAs MPs, I'm talking about local representation. That is what. So traditional local representation Sixth schedule area provides the traditional local representation. So that is the reason why these people of Ladakh are focusing on this sixth schedule to include under sixth schedule. Okay. And when you are talking about sixth schedule also, when you are talking about sixth schedule, Assam, Tripura, Meghalaya, Mizoram. So why we have given them sixth schedule is majority of the people are tribes. Now Ladakh people are also saying that more than 90, I think about 97% of Ladakh is estimated to be tribal population. So we fit into this category. That is the reason why recognize us as sixth schedule. So Ladakh demand for inclusion in sixth schedule is for autonomy. As I said, no, they are not saying that we don't. They are not saying that we want autonomy from India, but they are saying that we want autonomy in governing themselves, because you know, when we are talking about, sir, when we are talking about tribals, tribals have customary, their own, based on own customs, customary personal laws. As providing autonomy means nothing but giving them power to guide based on their customary personal laws. Okay, you understand what? That is the reason why when Uniform Civil Code is also in the news, you should understand. This is also very much important. So this might be also prospective question. Like which is the state which has been recently formulated Uniform Civil Code? Earlier it was Goa, now you have Uttarakhand. Now, when in Uttarakhand, Uniform Civil Code, it includes all communities. Exception is tribals. Because why we are excluding tribals is because tribals are governed based on their customary personal laws. You understand my point? So we have around 100, majority of the people are tribals. So that is the reason why we are demanding for autonomy to guide. Autonomy means nothing but to manage our own personal issues based on our customary personal laws. Now you understood what is the why people of Ladakh are demanding this to inclusion under 6th schedule. Okay, the 6th schedule under Article 24 provides for formation of autonomous administrative divisions, that is autonomous councils. Okay, autonomous district councils. They have some legislative, judicial and administrative autonomy within a state. Legislative means they will make laws based on their customary laws. Judiciary means they will give judgment based on their customary laws. Not the Indian penal, they won't follow Indian penal code. They will follow their own customary personal law and an administrative autonomy within a state. So it came into effect in 1950. Okay. So what are those? You can understand. Assam, Tripura, this we discussed, no? So now you understood why Ladakh is demanding autonomy, and central government argument is, see, you are saying that we are not having this local representation. Okay, but now central government has made some necessary changes also. Okay, so central government is arguing that 6th schedule is specially for northeastern states and Ladakh don't comes under this northeastern state. It's the story is same like special status to Andhra Pradesh. So special status has some geographical and some features in that Andhra Pradesh doesn't fit in. That is the reason why you see whether it might be Congress government, whether it might be BJP government is not upholding this concept of special status. ఏం కావాలో చేసుకోండి కానీ స్పెషల్ స్టేటస్ అనే వర్డ్ యూజ్ చేయకండి. అర్థమైందా? దట్ ఓకే. సో దిస్ ఈస్ ద స్టోరీ విత్ రెస్పెక్ట్ టు Ladakh. Is it clear? So central government is saying that although we made it as a Ladakh as an union territory, but we are providing more reservation to the people of Ladakh. Earlier there used to be less reservation for the people of Ladakh. Now we have increased more reservations from scheduled caste and scheduled tribes. Okay, so scheduled, not we say 97% is scheduled tribes. So they increased reservations. They also made some provisions which is catering to the need of Ladakh. but Ladakh people are demanding autonomy on the lines of 6th schedule. That you have to understand. But there are two sides of the coins which you have to understand. Okay, the arguments from both the sides you have to understand. అదే అంటున్నాను కదా, నాట్ ఫుల్ఫిల్డ్ కాబట్టి 6th అడుగుతున్నారు. బట్ పాయింట్ ఏంటి అంటే వాళ్ళకు యూనియన్ టెరిటరీగా రికగ్నైజ్ చేసిన దే హ్యావ్ బీన్ మేడ్ సమ్ స్పెషల్ ప్రొవిజన్స్ విత్ రెస్పెక్ట్ టు లడాక్. ఓకే, సో ద ఆర్గ్యుమెంట్ ఏంటి అంటే యూ హ్యావ్ టు అండర్స్టాండ్ ద టూ సైడ్స్ ఆఫ్ ద కాయిన్. నో ప్రొవిజన్స్ మేడ్ బై యూనియన్ టెరిటరీ డిక్లేర్ చేసేది ఎవరు? సెంట్రల్. అదే కదా, వాళ్ళు అన్ని అని అడుగుతున్నారు, ఉట్టిగానే అడగట్లేదు. దట్స్ వాట్ ఐఎమ్ సెయింగ్. యూనియన్ టెరిటరీ అంటే దే ఆర్ నాట్ గవర్నింగ్, అది చెయ్యట్లేదనే కదా వాళ్ళు మాకు ఆటోనామీ ఇవ్వు మేము చేసుకుంటాము అని. సార్ దిస్ ఈస్ ద ప్రాబ్లం. సి జమ్మూ కాశ్మీర్ ని ఇప్పుడు ఇక్కడ 2 points ఉన్నాయి. I deliberately not want to discuss. One thing is Jammu and Kashmir is saying that we want you don't consider as an union territory. Provide statehood to Jammu and Kashmir. In రోజులు ఏమన్నారు? Article 370 re-implement చేయమన్నారు. Supreme Court also upheld abrogation of Article 370. Now they are saying that we want statehood. Sir, this is a strategic move by Narendra Modi government. So Article 370 తీయకుండా యూనియన్ టెరిటరీ ఎందుకు చేశారు అంటే ఫస్ట్ ఫోకస్ ఆఫ్ పీపుల్ విల్ నాట్ బి ఆన్ Article 370. అదేంది, ఒక చిన్న పిల్లవాడు ఉన్నాడు. సో అదేంది, ఆ పిల్లవాడి దగ్గర ఒక చాక్లెట్ ఉంది, ఐస్ క్రీమ్ ఉంది, 2 తీసుకున్నావు, దగ్గుందని. ఓకే, ఫస్ట్ ఏం చేస్తాడు అంటే 2 ఇవ్వమంటాడా? ఫస్ట్ 2 ఇవ్వమంటాడు. నేను 2 ఇయ్యను అన్నప్పుడు ఏం డిస్కషన్కి వస్తాడు? ఒకటని ఇవ్వండి అని అంటారా? సో సి ప్రాబ్లం వెన్ యూ లుక్, దిస్ ఈస్ ఇన్ఫార్మల్ వే ఆఫ్ ఎక్స్ప్లెయినింగ్, బట్ ద ఫార్మల్ వే వెన్ యూ లుక్ ఫ్రమ్ an administrative perspective, why Narendra Modi government have dealt this issue in this way is Pahalgam incident is an example. Sir, okay, you asked, I'll explain. So Pahalgam is an example. In India, majority insurgency or terrorism is happening in Jammu and Kashmir, and you see why we are not able to control terrorism from 1990 till 2022-23. Insurgency or terrorism, majorly terrorism in valley is increasing. In Jammu and Kashmir, terrorism is increasing. The reason why they are not able to do is army is under the control, but administration is in the hands of people of Jammu and Kashmir or local government. So that is the reason why we are not able to coordinate properly and eradicate terrorism. So central government emanuntundi until and unless normalcy is restored in Jammu and Kashmir, we will make it as an union territory. Now entire union territory of Jammu and Kashmir will be under the direct control of central government. Now do you think that there will not be, see, when government want to take any action, you need not discuss 2 or 3 people in taking action. If there is a terrorist, okay, you want to finish that terrorist, you need not to take permission from state government. You can directly call central government, means nothing but lieutenant governor, and lieutenant governor has given permission, you can go ahead. See, what happens is when there is a security lapse, coordination is one of the major thing. You know, in 1962 war, India-China war, India lost this war not because of Indian army was weak. India lost this war because there was no coordination between 3 arms, army, navy and air force. You understand my point? And intelligence of these 3 are also not working collaboratively. So Anunchan is taking security of Jammu and Kashmir into consideration. We have made Jammu and Kashmir as an union territory. అలానే జమ్మూ అండ్ కాశ్మీర్ యూనియన్ టెరిటరీ, లడాక్ ని యూనియన్ టెరిటరీ చేశాం. అర్థమైంది కదా? సో ఇప్పుడు పాయింట్ ఏంటంటే లడాక్ వాళ్ళు ఏమంటున్నారంటే సరే యూనియన్ టెరిటరీ చేశారు కానీ ప్లీజ్ డెసిగ్నేట్ అస్ యాజ్ అన్ 6th schedule area. By 6th schedule area, what happens is regional autonomy they will get. Not regional autonomy, autonomy in governing themselves they will get. Means nothing but they will govern themselves based on their customary laws. అర్థమైంది కదా? మీరు అనేది ఏంటంటే సార్ పహల్గామ్ అటాక్ ఇప్పుడు జరిగింది కదా, ముందు ఎందుకు చేశారు అని. పహల్గామ్ లాంటి అటాక్స్ ముందు జరుగుతాయి అని ఎక్స్పెక్ట్ చేస్తే, యూ అండర్స్టాండ్ మై పాయింట్, సెక్యూరిటీ బ్రీచ్ ఈస్ దేర్ ఇస్ సో మచ్ ఆఫ్ స్కోప్ ఇన్ ఆఫ్ సెక్యూరిటీ బ్రీచ్. ఎందుకు స్కోప్ ఉంది అంటే బికాస్ అరే వెన్ when you understand borders between India and Pakistan, you have to understand this in the context of this. India is protecting border, means nothing but every day the focus of India is to stop attack of Pakistan. And other Pakistan, every day they want to attack India. So if one attack is not failure of the day. Failure means nothing but we successfully controlled the attacks every day, but we failed in controlling the attack on that day. అంటే దాని అర్థం ఏంటి అంటే పాకిస్తాన్ రోజు పొద్దున్న లేసి వాళ్ళ పని ఏంటి అంటే టు క్రియేట్ టెర్రరిజం ఇన్ ఇండియా. సో ఎవ్రీ డే వీఆర్ సక్సెస్ఫుల్ ఇన్ స్టాపింగ్ టెర్రరిజం. On the day of Pahalgam attacks, we failed. That doesn't mean Indian security failed. On that day we failed means nothing but if the intention of Pakistan to attack India all the time. So Anuj and Vilemannaru ante by declaring it as an union territory, first we will try to eradicate terrorism in the valley. And inkoti endi ante terrorism in Jammu and Kashmir you cannot eradicate easily. It takes so much of efforts also because there are sympathizers of terrorists also. Okay, you cannot deny that. Sympathizers means nothing but see, sympathizers also you cannot say they are against India. There are n number of factors also. N number of factors enti ante see, we have implemented Armed Forces Special Powers Act. So some army personals have deliberately misused these powers. When army is misusing these powers, now don't you think civilians will revolt against army? Revolting against army is nothing but revolting against government. Okay, so there are sympathizers అవ్వాలి అంటే చాలా మందికి అర్థం కావట్లేదు. జమ్మూ అండ్ కాశ్మీర్ ఇష్యూ there is so much layered approach you have to look. Sympathizers means చాలా మంది ఏమనుకుంటారంటే అచ్చా they are sympathizers of this terrorist means they are again. See, sympathizers has so much to do. Okay, so you have to understand that. See, definitely if at all you are sympathizing with the terrorism is wrong, but you are not satisfied with Indian army, that is okay. Okay, so there is also difference with this. So there are some people who are supporting you, who are providing hideouts to terrorists, that you have to figure out. So there is so much of security to be improved. That is the reason why we made this Jammu and Kashmir as an union territory. So that is administrative reason, that is true. But point in the end, but there is also hidden agenda. Hidden agenda just now I have explained. And in quote in the end, abrogation of Article 370 will give a way out for India if at all India want to capture POK. Okay, so this will provide India an opportunity. Okay, one hurdle, legal hurdle for India to recapture our POK is Article 370. Abrogation of Article 370 has given a way out for India to recapture POK. That we have to see. So, ఈ మధ్యలో అనుంచనే కదా ప్రతి న్యూస్ ఛానల్ పర్సన్ has become an analyst and looking into yes tomorrow there will be a war. Okay, సో ఆయనకి ఇన్ఫర్మేషన్ ఇచ్చి నరేంద్ర మోడీ ఫోన్ చేసి చెప్పిండు అనమాట. సో అండ్ ఓకే, సో ఎలక్షన్ కమిషన్, ఓకే ఎలక్షన్ కమిషన్ సార్, ఎలక్షన్ కమిషన్. So election commission, look at the article, which article it is. Now election commission, is it a constitutional body? Okay, next you have to understand that who appoints election commissioner, what is the tenure of election commissioner, what is the age of the election commissioner. So how election commissioner is removed. Okay, so go through this factual information. I'm cut shorting because this lectures of polity is going so much. So factual information which there is not much of explanation, you have to understand. Okay, so election commission is a quasi judicial body. This is one prospective question. Which of the following bodies they might be giving? They might give about election commission, they might give about what you say interstate council, they might give about what you say finance commission. Which of the following is quasi judicial body? So why election commission is a quasi judicial body, you have to understand. See, why election commission is a quasi judicial body is to settle disputes relating to grant of recognition to political parties and disputes arising out of allotment of symbols to them. Okay, and also as a during elections period also it has the power of civil court. Okay, in questioning, if at all in gathering information from the contestant. Okay, and also it can it can, what you say, disqualify the candidates. Okay, so based on that gathered information, so this is information which you have to know. What is this quasi judicial functions? Okay, so go through this question. Now next, Chief Justice of India. So what is the powers of Chief Justice of India under what article? Article 124 subclause 2. Okay, so what is the qualification? You have to go through this. Next, Finance Commission. So first question, you tell me, is Finance Commission a quasi judicial body, as we were discussing about Election Commission? Yes. Why? Okay, they will recommend fund allocation. అయితే ఫండ్ అలొకేషన్ రికమెండ్ చేస్తే క్వాజీ జ్యుడిషియల్ ఎలా అవుతుంది? Is Finance Commission a quasi judicial body? Yes or no? Yes. If yes, why? And what is the article with respect? Think about it. I want answer. If not today, tomorrow also. You can search and come with answer. So how I am saying no, Finance Commission is a quasi judicial body. You have to explain how. Okay. So Article 280 of Indian Constitution is talking about Finance Commission composition. It consists of chairman and 4 members with expertise in finance, economics. Okay. 6th Finance Commission has been appointed. Okay, sir, you see 15th there was a question with respect to comparison of 15th Finance Commission with 16th Finance Commission, for comparison with 14th Finance Commission, how tax devolution is done, horizontal tax devolution ela jarigindi, vertical tax devolution ela jarigindi. So there will be question on this line. So what is this, what type of grants has been allowed? So look into this thing. Okay, ad hoc judges in High Court. This is a concept which need explanation. Okay, so this is in the news. So Supreme Court recently has eased its previous conditions for appointing ad hoc judges in High Court. Why? To clear pending cases. Now you have to understand, which is very much important, is prospective question is ad hoc judges will be appointed, those appointed. Okay, those ad hoc judges who are appointed, I think I might have included it in the PPT somewhere else. You have to understand this. These ad hoc judges are appointed to look into criminal cases. Very much important. It is not on civil cases. Why do you think? Simple point. Number of cases, civil cases unde, criminal cases unde, civil issues. So as criminal cases burden, why do you think that ad hoc judges is majorly focusing on criminal cases? See, when we are talking about pendency of cases, civil cases there are pendency, in criminal cases also there is pendency. There is delayed justice in both criminal and when in respect to civil. Okay, you can understand a criminal like Kasab got judgment very after a few time. We cannot say delayed, but the gravity of issue which is done, he should have punished the next day. But it did not happen like that, right? So that is what. So now tell me, why ad hoc judges? ఇప్పుడు ad hoc judges అంటే ఏంది? రిటైర్ అయిన జడ్జెస్ వాళ్ళను 2-3 years కి you can recruit. So that is ad hoc concept of ad hoc judges. Now my argument is, if these judges during their tenure they would have done dealing with civil cases and criminal cases, but now by ad hoc judges, why are we giving them only criminal cases? So ఎప్పుడైనా క్వశ్చన్స్ ఇలా అడగండి, అప్పుడు ఈజీగా గుర్తుంటాయి. It is because criminal cases life and criminal cases needs quick, you understand my point? So that criminal cases need special attention and life is at stake when it comes to criminal cases. So that is the reason why criminal cases are being focused, and such that if ad hoc judges, additional judges are been focusing on criminal cases, the burden of criminal cases on the judiciary will come down. Okay, so this is one important point. You understand my point? So ad hoc judges in High Court to clear pending criminal cases. Okay, I have included. It ruled that ad hoc Supreme Court em cheppindi ante earlier what was the previous condition for appointing ad hoc judges was ad hoc appointments can be made even if the vacancies not exceed 20% of the sanctioned strength. So it ruled that ad hoc appointments can be made even if vacancies do not exceed 20% of the sanctioned strength. If at all the sanctioned strength is 100, generally it won't be there. Okay, so if at all there is vacancies of 20%, means in the judiciary there are only less than 20%, means 70 judges are there. So when there is vacancy of more than 20%, you can appoint ad hoc judges. But now they have what you say diluted this condition. Because why do you think they have diluted this condition is because pendency of the cases is when judiciary is working in full time also, case pendencies are more. Okay, the 20% condition was imposed by Supreme Court in an April judgment in Lok Prahari versus Union of India. You understand my point? What is that 20% condition? Means nothing but when if the vacancy is more than 20%. So they have what you said diluted that. So in Lok Prahari versus Union of India, the Supreme Court invoked Article 224A of the Constitution to allow the appointment of ad hoc judges in high courts to address the backlog cases. It set a guidelines. Okay. So the Chief Justice of High Court may exercise this discretion. Means nothing but only he can appoint ad hoc judges if vacancies exceed 20% of the sanctioned strength. So sanctioned strength kanna if there is 20 judges of High Court, but now the present strength of judges is only 15, means nothing but more than 20% is vacancy, then you can appoint ad hoc judges. So vacancies exceeds 20% of the sanctioned strength. Cases in category have been pending for over 5 years. Over 10% of pending cases are older than 5 years. The disposal rate is lower than the rate of new case filings. In this consideration, you can appoint ad hoc judges. So condition for appointment of ad hoc judges to high courts relaxed. Supreme Court has allowed high courts across India to appoint retired judges on ad hoc basis to address the backlog of criminal cases. Okay, so this judgment, now you answer, as I said, no, they have diluted those provisions. No, not diluting, they have changed those things. So Chief Justice Sanjeev Khanna and Gawai, they said that Chief Justices of High Court can recommend retired judges for appointment. Each High Court may appoint 2 to 5 ad hoc judges not exceeding 10% of its sanction strength. If sanction strength is 20, they can appoint 10%, means nothing but not exceeding 10% means they can appoint 2 judges as ad hoc judges. So these are the conditions. Okay, so these are the other factual information, this you can go through. Okay, Uniform Civil Code which is in the news. See, Uniform Civil Code, I think this is the only information from prelims perspective which is important. The state which recently has implemented Uniform Civil Code, and this Uniform Civil Code, be careful, it is applicable to all communities of the state and untadi, but that statement is wrong because scheduled tribes are excluded from Uniform Civil Code. Okay, so interstate. So sir, this PDF I am skipping because what are the provisions which are in favor of Uniform Civil Code? What are the provisions in favor of against Uniform Civil Code? Now, Interstate Council also, Interstate Council of, it is a constitutional body. It is established in Article 263 of Indian Constitution, and the council is basically meant to serve as a forum for discussion of various government. See, to uphold cooperative federalism, we have formulated this Interstate Council. Okay. And recently we see Interstate Council should meet at least 3 times a year. But why it is in the news is because Interstate Council has been neglected. It is not meeting. That is the reason why it is in the news. So you look at that. What is that composition of Interstate Council? Okay. Last, Money Laundering Act. Okay, so money laundering act was in the news. So money laundering, it is a criminal law. How do you define money laundering? Objectives of prevention of money laundering. Why you wanted, what are the objectives of money laundering act? Prevent money laundering, combat into illegal activities, penalize the offenders of money laundering, appointing an adjudicating authority and appellate tribunal for taking charge on money laundering matters. Okay, so the reason, yes, so the reason why money laundering is in the news, that you have to understand. So recently we see money laundering activities was been curbed by government, and money laundering issue is in the news. And for that matter, you know, under article 253 of Indian Constitution, it empowered central government. See, it empowered central government. See, when you are talking into the issue of money laundering, so it is a prerogative of both central government and state government. But money laundering act has been passed by central government because under article 253 of Indian Constitution, to uphold the international agreement, international conventions, central government can formulate a law even though if it is in state subject. So money laundering act is been formulated by central government using these powers. Now you see, money laundering is not a national issue. This is also an international issue. That is the reason why when we are discussing about financial action task force, what did we say? Prevention of money laundering and prevention of crimes on money laundering. You understand my point? So that is the reason why this article you should know under money laundering act. And what are the provisions of money laundering act, you can easily go through. So these are all the topics of polity. Okay sir, I know last 10 minutes కొంచెం స్పీడ్ గా చెప్పాను, బట్ ఐ ఆల్సో డోంట్ వాంట్ టు సాగదీయడం వద్దు, తొందరగా ఫినిష్ అయితే బెటర్ కదా. అండ్ ఇంకోటి ఏంటంటే, ఆల్రెడీ చదివిన టాపిక్స్ మళ్ళీ చెప్పుకోవడం ఎందుకు, అండ్ ఆల్రెడీ సార్ కూడా డిస్కస్ చేసి ఉంటారు. ఓకే, సో నౌ యూ గాట్, డిడ్ యూ కవర్, నౌ టెల్ మీ ఆఫ్టర్ దిస్ సెషన్, టెల్ మీ, did you feel like you felt like covering the topics which you have not covered? కొత్త టాపిక్స్ నేర్చుకున్నారా? ప్రిలిమ్స్ పర్స్పెక్టివ్, ఓకే, కొత్త నాలెడ్జ్ అయితే నేర్చుకున్నారు కదా. చలో, ఎనీవేస్ విల్ స్టార్ట్ అవర్ సెషన్ ఇన్ 15 minutes and we'll start with environment. Okay, environment.